We're claims free. Why should we worry?
I think the experience over the last few years with the increase in claims goes a long way to educating lawyers as a whole that we are in this together. And indeed, anybody that continues with an attitude that simply says, I can buy the insurance, may find themselves very soon without a marketplace in which to buy that insurance. Because the end result of that kind of attitude is that they will be very much isolated, or that their cost of doing business will be so high as to be almost prohibitive.
I'm too busy to be worried about what my partners are doing. Besides, if something did happen, my innocent partner coverage would protect me.
You've got to be aware of what's going on under your own roof. If all you're doing is doing your particular little area and you're oblivious to everything else in the office, then basically you're taking a big chance. And you don't have to.
I've known that client for a long, long time. He'd never sue me.
25 or 30 years ago, lawyers tended to be on a bit of a pedestal. Doctors were on a bit of a pedestal. People didn't think of suing doctors. They didn't think very much about suing lawyers. That's certainly changed. It's changed in the medical profession. It's changed in the legal profession. I think that lawyers are no longer seen to be as professional as they used to be.
The myths surrounding malpractice insurance are easy to dispel. The statistics speak for themselves. In the last 5 years, your levies have tripled. The number of claims has almost tripled. The average value of each claim has risen by 25%, from $12,000 to $16,000. 5 years ago, we could expect claims from 12% of insured members, and now that figure is something like 24%.
We have found in the past that only 25% of the claims actually result in a payout of a claim to a client. The other 75% are resolved without a payment being made. That doesn't mean, however, that there isn't a great deal of expense related to that. Even if we open a file, even if we spend time with a lawyer, reviewing the file with the lawyer and communicating with the client, we still have to spend a fair bit of money. And that's expensive to all of us.
Our purpose in providing this program is to stimulate constructive thought and dialogue, to focus on ways that lawyers who are claims-free can remain claims-free, and to reduce the number of claims and payments made.
Quite often, many lawyers think that a program such as this is for those who have had claims made against them or had claims paid out on their behalf, and don't recognize that all of us are vulnerable, and the old adage of there but by the grace of God goes anyone is very much applicable in this area. Most of us will not have a claim made against us, but it's such a random thing that the best of lawyers are as vulnerable as are those who are less well trained and who will have multiple claims. They all add up to a problem for the profession as a whole, and I think if any group of us were to put our heads in the sand and suggest that we weren't vulnerable, we'd be making a great mistake.
We purchase insurance to guard against financial loss. However, the cost of a claim can also be counted in hours or days of unbillable work and emotional stress.
It's going to take several hours just to report the claim to the Law Society, let alone if the claim proceeds to discovery. You're talking at least several days, maybe weeks of your time, which would otherwise be billable time, attending at the discovery, assisting counsel. And then, if it goes to trial, more weeks spent giving evidence at the trial and assisting counsel. That's no small amount of time, and it's very draining personal time, because you're constantly examining your own performance in a matter and having to hear a critical evaluation of your performance. That's a very painful process.
The effect is extremely broad and frightening. There are financial circumstances, surely, but as well there are serious professional circumstances. You can't simply ignore your partner's plight and go on each day carrying on your own practice, because you will be drawn into the problems created by his practice. There will be clients to speak to. There will be questions that have to be answered. There will be some type of accounting that you've got to try at least and give, even if you know nothing about his plight, even if you are totally ignorant as to the problem. You're going to have to let those clients of the firm understand what the firm is going through and why, for the time being, their work is being ignored. Beyond that, and beyond the immediate financial aspects, there's your home life. There's your your ability to be relaxed and at ease with your family and to enjoy them and to enjoy the activities that you do together. There is the trying to balance your home life with your work life, because sometimes the problems are so large they can take over your life entirely.
This program will provide the opportunity for you to consider the insights and experiences of the Errors and Omissions Department, to heighten awareness of your exposure and refine procedures and practices where it might be necessary. The facts are based on our experience. The fiction will be supplied by an actor who stands in for every one of the 16,000 lawyers we represent. The members of this firm knew that their partner's activities were, how shall I put it, a little unorthodox. They dealt with their discomfort by consigning him to a basement office, but the problem, of course, didn't go away and resulted in claims with a potential of $1 million. Now, our files illustrate many examples of partners who have not yet fully recognized their accountability and the potential risk, often operating without even a clearly defined partnership agreement.
We encounter situations where a group of people are practicing under the name or the flag of a partnership, but in fact they're not partners at all. They have no idea as to one another's personal lifestyles. They have no idea what one another is doing in their practice, how their clients are being handled, indeed even how their trust accounts are being handled, even though that trust account is a pooled trust account. There are marked differences sometimes between the way partners handle their trust funds on respect to the clients, even though it's the same partnership. And you get the impression, after examining one of these situations, particularly where one of the partners has gone off the rails and has actively stolen from the trust fund, that it wasn't really a partnership at all, but rather they were sole practitioners operating and thinking of themselves as sole practitioners, but over the years had developed a habit of calling themselves a partnership, even though in actual fact they weren't. The problem with that is that they are then caught in the very large net of the Partnership Act, and the consequences to totally innocent partners of a fraud of one of their own is really quite devastating. For example, because the policy is written on an occurrence basis and on a claims made basis, what frequently happens is all the claims come to light in one policy year. And there could be as many as 50 clients stolen from. And there's an argument that that means there were 50 occurrences, calling up 50 deductibles. Thereby, of the $2 million coverage you have for an aggregate year, that is, the aggregate coverage for a year would be $2 million, you would, as an innocent partner requesting coverage for those thefts, be liable for as much as $10,000 per claimant, or in excess of $500,000 in deductibles.
There are a number of activities which may heighten a partner's risk. Partnerships in which members engage in activities such as investment counseling, mortgage brokering, trust relationships, administering real estate, and so on, must realize that their partner may be found liable as a lawyer for errors and omissions committed while performing these activities, which in turn may lead to partnership liability. The precedent was set in 1987 by the Ontario Court of Appeal in the case of Courts in Saint-Pierre.
In that particular circumstance, one of the lawyers in the firm got involved with business dealings involving two other people. All three of those people signed a guarantee to the bank. What the lawyer investor neglected to tell his business partners was the fact that he was judgment-proof. When the business went bad and the guarantees were called upon, he did nothing because he didn't care. Obviously, he was safe. The other two people were caught holding the bag. Well, what they did is they brought an action against that particular person. And the Court of Appeal held that that investor was not an ordinary investor. That investor had been a lawyer of those clients, and therefore the duty that that person owed those people was greater than the duty an ordinary business person might owe another business person. And the court went on to also indicate that because that lawyer had been in a solicitor-client relationship with those people, his law partners were also exposed to a claim, and ultimately they were held responsible to those other business investors, even though they knew nothing about what was going on.
When liability arises out of activities which are outside the traditional practice of law, partners such as Warren Tobias reflect on how it might have been prevented.
There's an attitude that the administrative stuff is boring and they don't want to do it, but more importantly, like everything else in life, there's a denial that anything can go wrong. I am an educated person. I have practiced law for the last 16 years. I'm clearly not a moron, and yet I smoked cigarettes for 30 years. And I honestly believed, I mean, lung cancer is something that happens to someone else. That's not going to happen to me. I think that's why some of us would say that's academic. They would say, well, yeah, you know, it's a good idea to have a regular partnership meeting. But, I mean, I know old Fred. I mean, him and I, you know, we go back to you know, the 30s together. And, I mean, I can trust him, and, you know, I was there when his daughter was delivered, and we don't need that in our firm. That's what I mean when they say, you know, it's very academic. This doesn't really relate to me. What Tobias is saying, you know, may be a really good idea for a 14 or 15-man firm on Bay Street, but it doesn't affect me, Ed Jones, up in, you know, Owen Sound, practicing with a partner. The fact of the matter is that it does, and the fact of the matter is that you have to be aware of and conscious of what's going on in your firm. Instead of just blithely signing a trust check because some secretary puts it in front of you, the way I used to, ask her why the check is being made out. What is it in payment of? What file does it relate to? Who's it going to? Even doing that, you won't eliminate all the risks, but I think that you'll substantially reduce them.
Here's an example from real life. Two insured members formed a partnership. One practiced exclusively in real estate, the other exclusively in personal injury litigation. The practice was successful for 13 years until one day the real estate partner received a telephone call from the branch manager of the firm's bank.
Hello. Yes. Oh, hi, Rich. Fine. Fine. How are you? Not a chance. We just deposited a substantial amount last week. Yeah. Nah, it's impossible. No withdrawals for nearly a month. 10 checks in the last 6 months. All payable to whom? What was that name again? Spell it for me, will you?
The partner, who soon disappeared, had been withdrawing funds from the firm's trust account payable to his brother-in-law over a 6-month period. What's more, in 15 separate cases, the partner had settled actions on behalf of clients without their instructions, received the settlement funds, deposited them in the trust account, and issued checks to his brother-in-law accomplice. Now, the partner was eventually convicted of fraud, but the innocent remaining partner was left with an overdrawn trust account, 15 separate deductibles, the loss of a business associate, and the responsibility of caring for the former partner's files and clients, not to mention the devastating blow to the firm's reputation. In In many cases of partnership liability, we have identified the lack of a clear partnership agreement. Surprisingly, many lawyers view partnership in the same manner as a marriage, that a foundation of a relationship should exist merely through trust and confidence rather than by formal agreement. Without a formal agreement, many of these partnerships lack any process of internal review with respect to the ongoing activities of the firm, including disclosure of caseloads, file swaps, accounting reviews, and claims procedure.
We've seen situations in which there's been a breakdown in communication between partners and between lawyers. In some situations, a lawyer will say, "My partner committed fraud. There's nothing I could do about it." And yet, that innocent partner is left having to deal with all of the consequences. I think it's time that, as a profession, we have to step back and deal with some of these more difficult areas. What do you do in your firm when you see someone who's under a great deal of stress? Do you walk away and hope it'll get better? Or do you take a step forward to deal with it?
There are few of us that can practice as an individual island, that is, as a sole practitioner, even within a large organization. Even in the smallest of firms, there is an interrelationship between those members that should make each, to some extent, aware and responsible for the service that is being provided by the others. And that can take a whole variety of forms, from the mentorship that comes at the beginning, through education programs that are passed throughout the organization, to more formal processes by which individuals, when they have problems, have an outlet to get assistance with them.
Every firm needs to have some kind of a program that allows the individual lawyer to look to others for assistance and guidance. It may take many forms, depending on the size and culture of the firm.
The legal profession is the last bastion of individuality. What you have to guard against, though, is not allowing your firm to become a group of people who are sharing office space. You have to develop a collegiality there, so that you can talk to one another about problems, and you review what you're doing with your partners in some form. Each Monday we meet together, and the rule is it is not to go beyond 1 hour. We formerly had a problem because we'd have a big long agenda. It was difficult to get everyone together. Now we have a rigid rule. It doesn't go beyond an hour. If we don't finish the agenda, we go to the next week. Well, this is an opportunity for us to talk to one another, to socialize together in a sense, and to share problems that we have. So that format is working out very well. Also, the idea of having the law lunches and the retreats also is an opportunity for us to communicate with one another. Every firm of any size has to have both a moral leader and a business leader and a professional leader. So you have to have that spirit of collegiality in the firm. If you don't get along, it's a recipe for trouble, because you don't share problems.
Firms which place a high priority on administration will find that loss prevention is an added benefit. Many are concerned enough to have someone responsible specifically for administration.
The person doing the administration is best equipped to notice any real difficulties. They turn up often in files which ought to have been billed and for some reason haven't been billed, and that could lead you to client dissatisfaction, and you can nip it in the bud. It turns up with files which have been billed but not paid, and then you have an opportunity to look at the file and see why it hasn't been paid, and it becomes a little awkward when you're dealing with a partner, and generally the partner looks after it himself, but it's a matter of it coming to his attention, and that is done. When you're looking at an associate's difficulties, well, the associate will have some assistance in analyzing what should be done if there is a problem, but you've at least identified the problem, and once it's identified, it, in the usual case, is capable of being corrected.
When there is an error, I think it's even more important that the individual have another outlet for assistance. For example, in our firm, we have designated people who will, for the large part, take the decision-making about whether or not a claim is going to be made, the extent to which the client will be contacted, out of the hands of that individual, so that they're not put into a very defensive position, but rather they can have input, but also get the assistance from somebody who can stand aside from the individual problem and look more objectively at the best way to solve that.
Sometimes informal communication can disclose a problem which a more structured approach might not reveal.
I try personally to, if I don't spend time over lunch or time over a beer, or time cross-country skiing with every lawyer, to make sure that there is some contact with every lawyer in the firm, and if it isn't done every week, I think probably generally it's done every 2 weeks, and yes, you might miss one or two. Vacations are real things, and schedules are real things. But there is an effort to make sure that there is a direct contact, so that if there's any difficulties that should be discussed, there's certainly an opportunity to discuss them. The secret, I suppose, is, or if there is a secret, a single thing, it's to maintain communications among all those people with whom you work.
As a sole practitioner, it's very important that you have friends and colleagues that you can call when you have a problem that you're not sure how to handle. I can imagine that it would be so much easier to do a slipshod job if you didn't have somebody giving you a second opinion or, in effect, looking over your shoulder.
Lawyers who are practicing on their own, who aren't sharing space with other lawyers, often run into difficulties because there's really no one to talk to about problems they're encountering in their practice, whether it's a legal problem or whether it's a problem dealing with a client or some kind of administrative issue. There's not somebody immediately available for them to turn to. And one of the services that the Law Society offers its members is what's called the Practice Advisory Service, which is the equivalent of having a lawyer down the hall that you can go and talk to. Although it's the Law Society, it's a confidential service, so someone who calls the practice advisory isn't being put right through to the discipline department, for example. It's staffed by 3 lawyers who have a number of years of practice experience in a variety of different areas of practice, and someone who calls the service can get both that lawyer's perspective on a problem he or she may have had to deal with in practice, and also get the sort of added bonus of the Law Society's perspective on some of these issues as well.
There are times when it's not legal advice that's required, but other kinds of assistance.
One of the important things that we've tried to address, and I think a number of firms are looking at, is trying to help individuals to recognize when they may be vulnerable from a stress point of view, and to provide assistance to them that is anonymous, that is easy to access, and that is competent to help with those problems. A couple of examples may help. If somebody finds themselves under extraordinary tension or stress, and that may have initiated because of a family or marital situation, something that's totally outside the practice, but it's manifested in the inability of the lawyer to carry on their practice properly. We have made a group of consultants available to firm members to be contacted on a completely anonymous basis, so that the firm doesn't know who is making the contact, doesn't know which professional consultant the lawyer has contacted or any of the communications that are involved. And it's allowed those lawyers to find professional help. Some of it, and the Law Society is assisting in its LINK program with drug and alcohol abuse, but that's only one aspect of it. There's a variety of consultants that can help in many, many other areas. And I think the feature for lawyers is, first of all, to educate the individual as to the availability, and to educate them within themselves to recognize when they need assistance.
It's important that you are aware of your own responsibilities for what your partners do, and that you have procedures in place that will truly enable you to answer the question, who is my partner? The vast majority of claims arise from communication problems between lawyer and client, or lawyer and other third parties. The lawyer's credibility is called into question when there are ambiguities and uncertainties surrounding what advice was given, what instructions were given, what was expected of the lawyer, and what was expected of the client.
The one thing I see time and time again is the fact that lawyers know what they're doing and they know what they should do. They know the law, they're well educated. The difficulty is sometimes they get so busy that they don't bother sharing that information with the client. And as a result, the client doesn't know what's going on. The client doesn't have letters, the client doesn't have reports. They don't understand what has happened or why it has happened. If the client is unhappy with the result, the client may simply say, "You didn't do a good job for me." Perhaps that lawyer has done the best job possible. But once again, if the lawyer can't prove that, if the lawyer can't prove that all of these issues were discussed ahead of time, the client may be unhappy. Not because the lawyer didn't do a good job, but simply because the client wasn't kept informed.
Lawyers are sloppy. At least a lot of lawyers are sloppy, and they don't keep their clients advised. Maybe they have too much work. But I dealt with a case just the other day, actually a mediation for E&O for the Law Society. And a lawyer had acted for a client for a year and a half. And in spite of 22 visits by the client to the lawyer's office in that period of time, which required travel, some considerable travel for the client, there was not one single letter written by the lawyer to the client. Not one single report. And the client had requested in writing a report on many occasions. I mean, no wonder that lawyer got sued. He was just asking for it.
Usually, in claims that turn on advice or instruction, the problem in defense is not whether the communication or the instruction was transmitted, but what evidence there was of the transmission.
I think it's extremely important that a lawyer keep notes of meetings and decisions. But even more important is for the lawyer to send a copy of the notes to the client and ask the client to advise the lawyer if there are any errors or omissions in connection with the notes. Notes can be made later to try to support the evidence of a lawyer. Unless they're sent to the client, they don't really mean that much.
Consider this case.
Hello?
Hello, Linda. Your buyer just dropped off a check for $100,000.
Great!
And he's agreed to pay the balance in monthly installments once you deliver the software program.
Okay, sounds good. When do I get the money?
Well, the check's made out to our firm in trust, pending delivery of the software.
Listen, I'll deliver it to them tomorrow morning, first thing. How soon can we get a check from you?
Well, give me a day or two anyway.
Okay, I'll be over the day after tomorrow in the morning. How's that?
Yeah, well, that should work out all right.
The lawyer released the funds without ensuring that the software had indeed been delivered. It hadn't been, and soon after, the client went bankrupt. The purchaser sued the insured lawyer for breach of trust, eventually settling for $25,000. In this situation, the insured lawyer owed a duty not only to his client, but also to the settler of the trust. Most obviously, the entire problem would have been avoided if the lawyer had confirmed with the purchaser that the system had been delivered prior to releasing funds. However, this case also illustrates a pervasive attitude amongst the profession, as E&O's counsel in this case explains.
There's also a problem which comes up most frequently in trust cases, where the instructions which evidence the trust, which will quite often not come from the client but some third party, perhaps even unrepresented, the instructions will be ambiguous and crudely drafted. There's a common misunderstanding, I think, among the profession perhaps, that, well, if there's an ambiguity, I can rely on my interpretation, and so long as I complied with my interpretation of what the terms of the trust were, then I'm all right. And that just simply isn't the case, because what happens is a court will resolve the ambiguity in favor of the beneficiary or the party that created the trust, who's often the client or perhaps an unrepresented third party, and place upon the lawyer the onus of finding out exactly what was meant by the terms and resolving the ambiguity himself or herself.
Experience shows that if a case does go to trial, the client will often receive the benefit of the doubt.
If the lawyer has no notes and no correspondence with the client confirming the point in issue, then generally speaking, I would hold that against the lawyer, and I would tend to give credit to the client. The reason is, in part, that the client sees maybe one or two lawyers in the lifetime of the client, and what is said is extremely important to the client. The lawyer sees thousands of clients, and it would tend to blur. So very often the recollection of the client is correct, and the recollection of the lawyer is not correct.
Ongoing written communication with your client will not only result in the client's increased perception of good service, but provides a paper trail of evidence should it be required.
Lawyers are like anybody else. They don't like to convey bad news to a client, especially if it's going to affect their relationship with the client and their ability to work for that client in the future. However, lawyers, I believe, have a duty to fess up to the client and tell the client about the difficulties they face, and in that sense practice defensively. The example that comes to mind is the case of the lawyer who acts extremely competently for a client in a very difficult case. The case goes on through very, very long, lengthy discoveries, but the discoveries never seem to get concluded. The client becomes reluctant to proceed with the case. The lawyer tells the client the case is a difficult one. While all of this is going on, the case comes up for a status hearing on a number of occasions and eventually is dismissed. The client, who now believes this very questionable case has enormous merit, instructs the lawyer to appeal to the Court of Appeal. And the Court of Appeal, in this case, actually upheld the decision to dismiss the case on its merits at the status hearing. Now, the client turns on the lawyer and fails to remember the difficulties of the original case and proceeds to sue the lawyer as though the original case was a good case. Now, the lawyer is faced with a number of claims. First of all, he's faced with the original defendant's costs, which are substantial. Then he's faced with the loss of his own solicitor-client fees, which, by the way, are not covered. And then he's faced for the loss of the value of what the client now believes is a good case. Now, had the lawyer told the client in writing his real opinion about this case at any point over a period of about 5 years, there would be no lawsuit. But the client was never told in writing and now chooses to forget. And so the lawyer is faced with having to fight this on his notes. I go to the lawyer's notes. There are no notes. Even though it was the practice of the lawyer to keep notes all the time on the matters of this kind, Turns out that the notes that he kept with regard to these conversations with this particular client are no longer available. And so we're faced with the credibility issue between a naive client coming to a judge and saying, I had a good case and I've lost my good case. And the lawyer with all kinds of sophisticated arguments trying to convince a court that the case was a poor one to start with.
This claim could have been avoided if the lawyer had given a written opinion with regard to the difficulties, if the lawyer had confirmed the client's instruction in writing in a timely fashion, if the lawyer had advised the client in writing with regard to the progress of the action, including the status hearing, and if the lawyer had employed a diary and ticker system.
There is no doubt that perception is a very important part of legal service. Indeed, I think it was Marshall McLuhan a generation ago who said perception becomes reality. And I think that's very true in terms of legal service. When a client perceives that they have a caring, competent professional, they're much more willing to be reasonable even when errors have been made. And I think anyone who is on the defense side will quickly recognize that a professional's ability to communicate promptly and fully with a client, even when things have not gone as they should, will do a great deal to minimize that client's interest in making a claim, and even when there is a claim, and having it resolved much more easily. There is little doubt that one of the major areas of the increase in claims against lawyers is what is regarded as conflict. And that comes in a whole bunch of varieties, whether it's a lawyer who has moved from one firm to another and finds himself or herself on the other side of a situation than they faced at another firm, to a lawyer who is acting for two clients in the same kind of transaction. One of my other jobs at the Law Society is as a chair of the Rules Revision Committee looking at conflicts. And the work that we've done to date simply satisfies us that there is no easy answer to this difficult problem. And I think in the end result, we're going to have to educate lawyers to be much more attuned to the area or the subject of conflict than they are at the moment. Our conflict rule reads at the moment that lawyers may, in certain circumstances, act on both sides of a transaction. Unfortunately, a lot of lawyers read that sentence and think that the problem ends there, and they read may for an absolute permission and don't bother to think beyond that.
Nothing destroys credibility faster than an apparent conflict. And though conflict is seldom the root cause of a claim, if there's evidence of one, it becomes a much more difficult battle.
Conflict is a problem for a lawyer, because as soon as you have a conflict, then no matter what happens later on, if something goes wrong, you're liable, because you acted against, taking one interest against another interest. So once you've got the seed of a conflict and an error occurs later down the road, it's extremely difficult to try to allege or succeed in proving that the later error was in fact not negligence.
Now, here's a classic example where a husband and a wife have been involved in a car accident in which the husband was the driver.
Now, where the lawyer takes the case of both the passenger and the driver, he's immediately sowing the seeds for a later successful lawsuit against him if something goes wrong, because he's taking the case of the husband against the wife, and the wife against, particularly the wife against the husband. And the difficulties that occur later when a claim isn't issued in time, no fault benefits aren't sought in time, the prospect of an unidentified vehicle emerges, the prospect that the husband, even though it seemed like a very simple accident, is at least partly to blame, and the other tortfeasor may or may not have any insurance. All of these things come into play. But the basic root cause of the lawyer's exposure here is the fact that he took on two interests, which interests fundamentally conflicted.
A basic problem that I've been seeing in the conflicts is lawyers simply not being attuned to questioning themselves as a transaction plays itself through. Is there a conflict at this stage? Is there likelihood for a conflict tomorrow with a change of circumstances?
How do you avoid a conflict? Well, if you have an interest, disclose it. If you're acting for more than one client, be cautious, look around, and where potential conflicts exist, ensure that your client understands the implications by outlining your concerns in your retainer letter. It's worth taking the time, when in any doubt, to contact the Practice Advisory Service. The lawyer, acting for both husband and wife, who are mortgagees, receives funds sufficient to discharge the mortgage. He gives a draft discharge to the husband to take home for both he and his wife to execute. The husband returns with executed discharge, receives a check payable jointly, deposits it in a joint account, and subsequently withdraws the sum for his own personal benefit.
But we gave him a draft discharge to take home and get signed. He brought it back with his wife's signature on it. Yeah, we made the check payable to them jointly. They've been separated how long? 6 months. Where? With whom?
The wife takes the position that the signature on the discharge was forged. Now, ultimately, this claim was resolved without payment on the part of the lawyer, but only after a complicated piece of litigation.
It's very important, in my view, for lawyers to be careful about the assumptions they make about family relationships. The assumption that a marriage is a happy one and that both partners are in agreement is commonly made to a lawyer's detriment. The assumption that a child's wishes or a child's instructions for what should be done with the family home are in accordance with the parents' wishes, again, is commonly made to the detriment of lawyers. It's very important for lawyers not to treat families or family relationships as units, but to ascertain precisely what the desires, wishes, and instructions are of each individual family member.
Claims are also made by a person whom the lawyer doesn't even consider to be a client. Now, one example would be the phantom client.
I suppose the best way of defining a phantom client is a client or a person out in the public sphere who contacts a lawyer, but the lawyer himself never really regards that individual as a client. But all the duties that a lawyer owes the client are owed to this person in the public sphere. And when the person in the public sphere comes in and claims the solicitor-client relationship existed, claims that he relied on the lawyer's advice, the lawyer has practically no answer, because the lawyer generally doesn't recognize or can't remember this individual, let alone the merits of the claim nor the advice that he gave. So the simple rule here is to don't let that happen. Don't tend to give advice on the telephone to people you don't know. Don't have people rush into the office breathlessly with a story and then quickly brush them off. Take the time to get their name and address, and take the time to write a covering letter as they leave the office. You'll never bill for it, but if you can write 100 letters like that and save one lawsuit, you're well paid.
We've had situations in which lawyers have gone to shareholder meetings on behalf of the company, but the shareholders who are there think, that's a lawyer. That lawyer is going to give advice, And that advice will be to my benefit. It's very important if you're involved in any kind of transaction or relationship and you're not acting for people, that you clarify that. Because at the end of the day, if something goes wrong, they may look at you and try to blame you for something that has gone wrong.
When considering your fiduciary duties, it is not sufficient to simply consider your client's interests. It is necessary to consider as well those parties who will be affected by your work and your duty of care to third parties.
One case that comes to mind is of a lawyer who acted on behalf of a developer in connection with a condominium development. What happened was units in the development were pre-sold, and the lawyer received the deposits into his trust account. The agreements made no provision with regard to interest, and the developer client asked the lawyer to please pay him the interest. The lawyer, not thinking about the beneficiaries for whom he was holding the deposits in trust, simply complied with the client's instructions. Unfortunately, the developer went bankrupt. The development did not proceed, with the result that the lawyer found himself at the end of claims by as many as 50 potential condominium purchasers, claiming the interest on their deposits. That problem could have been avoided simply had the lawyer contacted the condominium purchasers and obtained releases from them before paying the interest to the client. But because he didn't really think of those condominium purchasers as people to whom he owed an obligation, that didn't happen. What is truly horrific about that case was because there were 50 different condominium purchasers, there were 50 separate claims and therefore 50 separate deductibles. So that was a very, very expensive claim for the firm involved.
Recently, we've had a number of claims arising out of the loss of clients' money. It's important that lawyers are very careful that they don't take on more responsibility than is necessary. A client may come to you and say, I'm involved in a condominium transaction. Please, will you take on the monitoring of all the deposits? If your firm or you agree to do that, please make sure that you have sufficient support staff to deal with the complexities of that kind of transaction. As money is flowing back and forth in and out of your trust account, it may not always be as carefully monitored as it should be.
In trust cases, a lawyer owes a duty not only to his or her client, but also to the settlor and beneficiaries of the trust to ensure that the terms of the trust are complied with. Sometimes lawyers are so used to advancing the interests of their clients that it's an easy matter to neglect obligations owed to non-clients. Yes, my friend, it's too late. You've missed the claim deadline. Time is most lawyers' enemy. We see far too many claims where deadlines are missed, searches rushed, tasks delegated that shouldn't be, or inadequate written communication. And then when things go wrong, the pressure is compounded by the time spent defending a claim and the associated stress. Working against the clock is invariably part of a lawyer's day. However, there's no reason why time can't be properly managed.
Time management relates to loss prevention because, for one thing, if you can reduce or eliminate the interruptions you have to your work, you're less likely to overlook something important that the distraction might cause you to overlook. You aren't put in a position of starting one thing, interrupting it to do a second thing, interrupting that to do a third thing, and then by the time you get back to the first thing, first of all, you've forgotten where you were. You may have forgotten what you were focusing on when you were dealing with that first project. And again, it's very easy to overlook something crucial that you aren't going to pick up on again later. Managing your time also helps to reduce stress, and reducing stress in and of itself helps cut down on errors or omissions. It can be very helpful if you set time aside to deal with a specific task. My technique is to write it into my diary that on such and such a day this is what I'm going to do. Then I don't have to think about it again. I know that when I get to that day in my diary I've got the time blocked off to do it. I don't have to worry about it. I can put the file away and pull it on the day in question, and that helps keep my stress level down. Also, I think exerting control over your time means you're better able to give timely attention to matters. You aren't scrambling at the last minute to issue a statement of claim because the limitation period's expiring today. You've got yourself organized so that you can deal with things when and as they should be dealt with, and get your statement of claim issued or get your requisition letter or whatever dealt with in lots of time.
Managing time effectively also means that when that last-minute emergency happens, as it invariably will, you have the energy to deal with it.
Most of us are familiar with having a diary and marking ahead those events and tasks that are important, including things like limitation periods. But one easy way to avoid problems is to have a backup system that isn't entirely dependent on the individual professional. For example, it may be a secretary, it may be a records clerk, it may be a separate computer system, something that the lawyer can't ignore or manipulate, that brings information to their attention on a regular basis so that they're continually aware of the obligations that diary system imposes on them.
The diary is on the computer and we both input into it, and usually at the beginning of the week we will look at what is scheduled for the week and try to do a short projection of tasks that need to be completed by a certain day. For instance, if there's 2 days consumed at the end of the week with where she's going to be out of the office all day for both of those 2 days, then we'll have to look into the next week and see that there's something that has to be ready for the Monday. So we'll bring it forward for earlier in the week and deal with it then. We sort of rely on each other to work as a team. For things even as simple as a meeting perhaps that she's scheduled to attend and knows she can't go to, but wants some issue raised at the meeting or wants some input on the issue that's going to be raised at that meeting. So at the beginning of the day, in her diary, I will put a prompt for her saying, call someone to let them know how you feel about this issue that's going to come up at the meeting later in the day that you can't go to. The diary is really a tool that's indispensable. You have to keep it updated. Make sure you refer to it frequently, because appointments can be slotted in by either one of us, and without ever actually telling each other. And if you don't refer to it frequently, then you're going to miss things. And the lawyer will tend to hopefully learn that they can rely on their secretary. If they've scheduled a meeting on a specific file on Wednesday, their secretary is going to bring the file to them or discuss the file with them perhaps on Monday and say, now, is there anything you need me to prepare for you for this meeting? What do you need?
Time is money, and timely billing practices can save money.
Regular billing practices, I think, is a very good way to help with loss prevention, because it's a fact that a very significant bill sent out after a long period of time will have a lot of the work that's represented in the bill lost to the client's memory.
One of the secrets of time management is to delegate responsibility. The difficulty is, however, if you don't follow up, the task that you've given someone may fall off the ends of the earth.
It's important that if you delegate something to someone that you follow up, and you follow up on a regular basis. And in that situation, the task itself will not be lost. The other thing is, if you don't follow up quickly, you may follow up in the 11th hour, and the day you're set to go to pretrial, or the day the real estate transaction is to be closed, you realize there's a gap in your information, and you scramble around trying to fill that gap. If you make sure that things you delegate are given back to you, then those gaps will be filled at a much earlier time, and again, there'll be much less stress involved.
Here's one from our files. A busy law firm has the habit of issuing statements of claim at the last minute. The claims are prepared and left in a tray for the process server to pick up, issue, and serve. The process server either is not called or does not pick up the claims in time, resulting in many missed limitation periods. Yes, it actually happened. And the claims cost as much as $250,000. Could something like that happen in your firm? Papers assembled in a bag on the boardroom table, a filing cabinet, a pickle jar, and some very conscientious office staff. What happened as a result cost thousands of dollars in claims. The broken pickle jar had sat in the fridge for too long. It was time to clean up. Turns out it was vital evidence. That night, when the cleaning person went into the boardroom, she just naturally assumed that the paper was for the garbage, when in fact they were important client documents. A lawyer leaves a law firm. Needing the filing space, a file cabinet of files thought to be closed is boxed and sent off-site. Later, a partner assigns the collection of an outstanding accounts receivable to a junior who pulls the file from storage. It's found to be open along with numerous others, many of which had missed limitation periods. Were all of these claims just quirks of fate, simply bad luck? What they point to is lack of care in following procedures, or perhaps no procedures at all.
Most lawyers, when they go to law school, want to do one thing when they graduate, and that is practice law. They don't want to be business people. They don't want to keep track of their hours. They don't want to be responsible for support staff and what support staff are doing. They don't want to be involved with the training of juniors as juniors enter the firm. Unfortunately, it's impossible to practice law without paying attention to other details. It's important that you know that your office is managed properly and that there are systems in place which will protect you.
In our illustrations, claims could have been easily avoided if there had been safekeeping procedures for files and valuables and file closing procedures.
We have a strict file room discipline where files are broken down into parts, every part is identified, and when a part is removed from the file room, it's signed out by a responsible individual. And there are severe consequences if that discipline is not followed, because we simply can't afford to lose a pile of important documents. The regularity of the diary system itself and the attention to the files, even though it may be a Passover kind of look at a file, is at least attempted to be done on a regular basis, so that every file is looked at every 30 days, regardless of how active or inactive it is, just to double check, make sure that things are rolling.
We find that in many situations, lawyers have the information at hand, but it's not communicated within the office. For example, in real estate files, there may be a zoning check done, but nobody takes that information and relays it to the actual agreement of purchase and sale. And as a result, the problem isn't discovered until after closing. The file is open, and lo and behold, the information is there, but no one paid attention to it.
Errors like this can be linked back to poor communication within the practice, but part of the problem can also be improper delegation.
My experience in going into lawyers' offices is that I run into two types of delegation problems. One is that they delegate too much to their support staff, so you have one lawyer with 14 support staff. The lawyer rarely, if ever, meets with the clients, and in effect the support staff are doing a lawyer's job with inadequate supervision from the lawyer. And we see a lot of problems arise where the lawyer simply hasn't kept an eye on what's happening on a file, doesn't, for example, review a title search adequately, doesn't review the clauses in a separation agreement properly, and when problems arise down the road, the lawyer isn't remotely familiar with the problem, obviously has no notes in the file to support his or her understanding of what had gone on, and so is basically at the mercy of and responsible for the errors of support staff. At the other extreme, we see lawyers who don't delegate anything to support staff, lawyers who open their own files even though they have a secretary who's perfectly capable of doing so, lawyers who will not let their support staff respond to client inquiries. And again, I spend a fair bit of time working with lawyers and their support staff to discuss what appropriately can be delegated to the support staff, what should not be delegated to the support staff, and trying to find a happy medium between the two extremes.
Here's a claim which was resolved without liability on the part of the lawyer, but nevertheless illustrates the key role support staff can play in loss prevention.
Oh yeah, I remember this. That's okay, go ahead with it. Oh, and this just came in. It's a non-refundable deposit on the purchase agreement. Deal's okay, so deposit that in our trust account and issue a check payable to the vendor. The name's there.
The bookkeeper follows the lawyer's instructions, and when she turns the check over to endorse it, she ignores an endorsement by the drawer of the check, who is not a party to the agreement that the funds shall be held in trust pending the closing of the transaction. She issues funds as directed, the transaction does not close, and the payor sues the firm for return of the deposit.
The essential issue is that support staff look for the unusual, the strange and the bizarre, and that they not necessarily do anything about it other than bring it clearly to the attention of the lawyer for his decision or her decision. That's what's important about that issue. The issue of delegation generally is a difficult one. It's of importance to clients quite often that work be delegated because it saves costs. It economically uses time in a way that saves clients money. Having said that, it's important that a lawyer remain responsible for what's delegated and not simply lose track of it.